Hi everyone, welcome to the live virtual classes of Board of Studies ICAI. We are discussing interesting topic, that is General Clauses Act 1897 under paper 2 Corporate and Other Laws. I am Dr. Vijay Kumar Singh and I will be leading you through these 4 sessions which we are going to discuss in this part of our paper, that is General Clauses Act, 2 sessions, and then we will have 2 sessions on interpretation of the statutes. Being a lawyer, I see this particular topic in a different context, and day in, day out for a lawyer, interpretation is very, very important. And I consider so is it important for our CA colleagues and company secretary colleagues for a simple reason that they also need to interpret the provisions of law to a given situation or facts. And every time you will be faced with a different situation or a fact which you need to address by way of interpretation of laws. And hence, it becomes important for us to know how interpretation works. How do you look at the provisions and try to understand them? And to understand that, you require different legislations. And one of the legislations which support in this interpretation is the General Clauses Act. So ideally speaking, General Clauses Act, does not make any change in the existing law or existing statutes, but it aids into interpretation. It helps in interpretation of that statute. So this is what exactly is the background with which we will move. And while we go along, probably you will understand it more better that why General Clauses Act and interpretation of statutes is important for you. Nonetheless, this is a topic which is part of your syllabus, so you need to read it for your examination purposes, and hence this is also important from that context. But I was trying to highlight it from a context of, as a professional, why you will require these legislations in your practice when you become CAs, and hence this is part of this particular syllabus. Let me move further and we go ahead and try to understand what are the learning outcomes of your session. And the objective of these 2 sessions would be that at the end of these sessions, you should be able to explain the purpose of the General Clauses Act, why General Clauses Act is there. Secondly, you should be able to mention or you should be able to acquire some basic understanding of the legislation, how the legislations are framed, what are the major components of a legislation, how legislation is to be read, and where you find what. That is also very important because reading legislation is a kind of a skill which you gain over a period of time. But I will try to explain you in my session today that how legislations are framed, what are the major heads in a legislation, and how do you read the legislation. Third point is knowing the general definition under the Act. So General Clauses Act has got a definition clause which has got some general definitions, and these general definitions are important because any central legislation you pick up, these definitions would be applicable to those central legislations also. I will come to that in a while and I'll explain you what I mean to say when I say this. And then you should be able to identify the general rules of construction. There are basic rules of construction. We will try to see which are they. And then explain powers as to orders, rules, etc. made under the enactments. So what is the powers as to orders, rules, etc. which are made under enactments, and gain knowledge of other miscellaneous provisions. So this is what is your learning outcomes of this chapter, and we will try to see how it operates and functions. Let us move ahead with the scheme of your study material. If you have a look at the General Clauses Act, they are arranged into the following sections or following parts. So there is a preliminary section, or any legislation has got a preliminary section. So this is the preliminary section, section 1. It comprises of section 1. And then which is followed by general definitions in sections 3 to 4a. And then general rules of constructions we will try to understand from section 5 to section 13, which basically tells us that what are the major or general rules of construction. And then we will also have a focus on powers and functionaries, that is section 14 to 19. We will see what are the powers of different functionaries, and then provisions as to orders, rules, etc. made under enactments. So if this is section 20 to 24, and then miscellaneous provisions from 25 to 30. So as you can see, this is a very small act, a thin one with 30 sections, and we are trying to understand how this applies and is applicable to general interpretation or interpretation of different laws. So with this background, let us have a look at in a snapshot the different sections which I just told you in my previous slide. So you can see here preliminary section 1, then general definitions section 3, 4 and 4a. 4a is definitely added later. As you can see, any legislation which amends or brings in new sections, they number it as A, B, like that. So for example, in section 5 also you can see there is section 5A, which is actually repealed now. Section 6 has also got 6A, which is again an inclusion, which may have happened later. So we will talk about these amendments as well. The Bare Act, which I am having at present in my hand, is amended up to 2021. That is what I see. And I don't find that there is any amendment after that which has come in the General Clauses Act. So the General Clauses Act is a legislation which is a British era legislation, 1897. That is what the law says, the General Clauses Act of 1897. In my previous slide, wherein the cover page was there and I showed you the General Clauses Act, you would have noticed one thing that I have mentioned there at the bottom. You must have seen this is the Karnataka General Clauses Act. You are able to see here 1899, the Karnataka General Clauses Act. So this you will find there is a difference because in the states, different states have their own General Clauses Act, because the General Clauses Act of 1897 applies to all central legislation and not to the state legislation. And for state legislation, we have got different laws or different acts for different states. And I will touch upon this in a while in some detail. And here the example is the General Clauses, Karnataka General Clauses Act. Till this particular point on the background, if anybody has any questions, I will be happy to take that. Let me see your chat box. What do you say? Okay, that's good. Let us now move ahead and talk about the objects and reasons of the General Clauses Act. So there are various Supreme Court decisions in which the objects and reasons of General Clauses Act has been discussed. General Clauses Act also talks about the objects and reasons of General Clauses Act, and which we will touch upon in a while. But there is an explanation which was given by the Law Commission of India in its 183rd report on a continuum on the General Clauses Act 1897. And this 183rd report, the Law Commission, pointed out the objects and reasons of General Clauses Act as under, and it said in para 24, interpretation statutes such as General Clauses Act are enactments intended to set standards in construction of statutes. So basically, it is trying to say that the General Clauses Act are meant for helping the interpretation or construction of statutes or deriving meaning out of the statutes. The expression construction here, as the words is construction and interpretation. In my lecture on interpretation, we will talk about this difference in detail. But just for your information, construction basically is to construct something, to come out with a meaning where there is some ambivalence, or where there is some problem or you are not able to interpret. That statute you need to construct. So the expression construction is of seminal importance as it orients towards enabling a seeker of the text of a statute to understand the true meaning of the words and their intendment. So a word may have different meanings, right? And you need to decode as to what is the meaning of that word in that context. So we always say context is the king, and the word which features into a statute or a legislation, you need to find out what that particular word means. Some of you ask me whether I am practicing tax or GST or something. I am not a practitioner, by the way. I am a professor. So I teach corporate laws, and business laws is my area. Taxation statutes, if you look at it, there this particular meaning of a word means a lot, right? So because you have to bring a particular word into the definition of taxability or non-taxability, and that needs to be, looked at very, very carefully. And hence, the construction of the true meaning of a word in a statute is very important, particularly from the taxing statutes perspective, but otherwise also it is important. Apart from setting coherent and consistent method of understanding enactments, the interpretation statutes like General Clauses Act also subserve the purpose of reducing prolixity of legislation. So when I say prolixity of legislation, and this we have been, and government has been highlighting, and you people are all aware that we are trying to move towards simplification of legal language, and laws should be made simple. And General Clauses Act tries to or attempts to reduce that complications in legislations by way of providing some standards. That is what is one of the objectives of General Clauses Act. The standard principles formulated in the interpretation of statutes must therefore be read into any and every enactment falling for considerations. And this is what is one of the major focus of General Clauses Act. In para 27, the Law Commission says, in the ultimate analysis, interpretation of statutes or definitions in interpretation clauses are only internal aids to construction of a statute. There are two kinds of aids for constructing a statute or interpreting a statute. One is known as external aid and the other one is known as internal aid. Internal aid, basically, you will find it in the statute itself. And whichever law you are looking at, in the law itself, you will find the aid. Like, for example, definition clause is an internal aid to construction. Whereas there may be some external aid, like, for example, you move on to the dictionary or you move on to the parliamentary debates. These are external aid to construction of a statute, and courts use both these type of aids in utilizing the, or interpreting the laws. And it is actually, the interpretation is exclusive domain of the court, and none of us are capable of interpreting actually or constructing a statute, because if you construct, it has no meaning. Basically, you have to put up that argument to the court and court has to agree to it. So by way of a judicial decision only, that construction or interpretation of the law comes into force, and hence it is the exclusive domain of the court to interpret. That is what it tries to say. So this particular thing has also been highlighted and emphasized in Pernod Record India Private Limited versus State of Madhya Pradesh. This is the case 2024 INSC 327. So this is how we understand the objects and reasons of the General Clauses Act. I hope this slide gives you a brief background why General Clauses Act exists and what are the main objects and reasons of this. As I was telling you that there are different state General Clauses Act. So this is just an example. So this you can see, this is Bengal General Clauses Act 1899. So this law applies exclusively to the West Bengal. It is meant for that particular state. Though you will find that this law is also of pre-British era, because Bengal used to be one of the major occupations by the Britishers, and they came up with laws relating to these 3-4 presidencies. Bombay and Bengal were one of them, where the older legislations, the British era legislations, still exist. One of them is this particular law. So for states, you have different General Clauses Act. When we are talking about General Clauses Act, we are discussing only the central legislation. Now, if you move on to the object, purpose, and importance of General Clauses Act, this has also been dealt with under the General Clauses Act introduction, and you will find that there are different purposes of General Clauses Act. Okay, and I was reading one of the books of modern statutory interpretation by K.N. Chaturvedi, And Mr. Chaturvedi has, began the General Clauses Act in his chapter 17, and he says, words are medium, and no medium ever carry the message perfectly, right? And hence there is a need for interpretation. In India, the statute which lays down rules of interpretation of all central acts is known as the General Clauses Act 1897. So if you see, uh, words have different meaning. And that is what is the focus here. So if words have different meaning, you need to find out the exact meaning for getting the actual meaning out of that law. And that is the purpose of the General Clauses Act. So one of the purpose of General Clauses Act is to shorten the language of central acts. So just imagine if General Clauses Act has got 30 clauses, okay, and 30 sections, and in these 30 sections, there are detailed explanations. Now, if all these explanations were to be repeated in all central legislation, the legislation would become more bulkier, right? So say, for example, there is a definition in General Clauses Act, unless there is a requirement to repeat them, we follow General Clauses Act in whatever central legislation you are referring to. So it shortens the central acts. This is one of the purposes of General Clauses Act. Second important purpose of General Clauses Act is to provide as far as possible for uniformity of expression in central acts by giving definition of a series of terms in common use. So say, for example, affidavit is defined in General Clauses Act. So affidavit, wherever used in central legislation, will mean same thing if General Clauses Act provides that. Otherwise, what will happen is that different clauses, different acts may have different kinds of definitions, and that will create problem because one law will say something, another law will say something. And I can give you an example. And this example you may be reading in securities laws. For example, there is a definition of control, right? CONTROL. So the definition of control under the company law is different than the definition of control in CCI, that is your Competition Act, and definition of control in SEBI law is different. So this definition of control, which is there in SEBI and Competition Commission, is different, and that leads to different results. And you will see that in case of mergers and amalgamation proceedings, these two definition creates a bit of a confusion. It had created a confusion before also, and there are case laws to that effect. And hence, it is important to give that uniformity of expression of central acts by giving definition of a series of terms in common use. Third important function or object or purpose of the General Clauses Act is to state explicitly certain convenient rules for the construction and interpretation of central acts. So there are some rules of constructions which are given in the General Clauses Act, which I will touch upon in a while. Then to guard against slips and oversights of by importing into every act certain common form clauses, which otherwise ought to be inserted in every central act. So this is very important, and I don't know how many of you follow legislations, but if you will see legislations, there are amendments wherein there are words which are missed, there are some terms which are missed. So there is no guarantee that if you copy everything from General Clauses Act in different central legislations, everything will be brought into in the similar sense. There may be drop of word which can be there. There may be spelling mistake which can be there if you are incorporating these terms every time into a central legislation. And hence, it is provided that rather than repeating them again and again and again, provide it at one place. And this will save the slips and oversight of importing the terms into the different statutes. So this is one of the another important reasons for having the General Clauses Act, or you can say the object of having the General Clauses Act. In the case of Chief Inspector of Mines versus Lala Karamchand Thapar, the court or the Supreme Court highlighted the purpose of the act is to place in one single statute different provisions as regards interpretation of words and legal principles, which would otherwise have to be specified separately in many different acts and regulations. The purpose of the act is to avoid superfluity of language in statutes, wherever it is possible to do so. So whatever General Clauses Act says whether as regards to the meaning of words or as regards legal principles, has to be read in every statute to which it applies. So this is what Supreme Court has interpreted or has underlined the purpose of the General Clauses Act. I hope this gives you a bit of a clarity on the purpose and objects of General Clauses Act. Let me now give you an interesting example of interpretation because I am using this term often, and you may be thinking that we are talking about interpretation. How does it make a difference, right? So just to take this example of interpretation in one of the scenarios, and this scenarios relates to the insolvency and bankruptcy code, and you will it is an interesting example, not insolvency bankruptcy code, actually SARFAESI, but relating to insolvency. So this matter relates to appointment of advocate to take possession of secured assets. So if you may be aware that whenever there is insolvency or maybe there is a loan default, under the SARFAESI, banks are having powers to take into possession the hypothecated assets or property. And in this case, recovery of loans under the SARFAESI Act, the question arose before the court whether it is open to the district magistrate or chief metropolitan magistrate to appoint an advocate and authorize him to take possession of the secured assets and documents relating thereto and to forward the same to the secured creditor. Now, on this particular point, it may appear to be very simple, right? That DM has got the power, CMM has got the power to take into possession the secured assets and the documents and then hand it over to the creditor. But this is not that simple as it appears because different courts or different high courts have interpreted this term in a different way. So there have been conflicting decisions of various high courts on this question. Some used to say that, okay, fine, you can appoint an advocate. Some used to say that, okay, no, you cannot appoint the advocate because it is a duty of the CMM and DM to do it himself. And there cannot be an advocate which can be appointed for this position. However, Supreme Court discussed three types of subordination in this case. And it said there is something which is called administrative subordination. There is something which is referred to as statutory subordination. And there is one which is called functional subordination. So Supreme Court coined this particular term and brought this and said, applying the functional subordination interpretation, Supreme Court held that the judgment and order of the Bombay High Court impugned in the present appeals is declared as not a good law, whereas the conclusion of the three high courts, namely High Court of Kerala, Madras and Delhi on the question under consideration were upheld that there is no prohibition either on engaging any advocate commissioner for taking the position of these secured assets. So it is purposive interpretation. Basically, they tried to do a harmonious construction over here. So within the meaning of section 14(1)(a) of the Securitization and Reconstruction of Financial Assets and Enforcement of Securities Interest Act, that is called SARFAESI in short, it is common knowledge that the respective jurisdiction, there is only one CMM and DM. So if he is expected to reach at every location himself for taking possession, in some jurisdictions, it would be impracticable, if not impossible, for him to do so, owing to large number of applications in the given jurisdiction, being a commercial city, like for example, Bombay, or maybe Delhi, or maybe any other big city nowadays. It is very, cumbersome task for the DM and CMM to take possession of these things. And accordingly, strict construct would defeat the legislative intent and purpose of the enacting of this particular legislation. And so you can see here, the court has given a purposive interpretation in this case. So this is a judgment dated 6/11/2019 in so-and-so writ petition, that is NKGSB Cooperative Bank versus Subir Chakravarti in 2022. This is the decision which was given. So this case shows you the highlight of the interpretation, that how interpretation is done. There are two questions. Let me answer them. One of them is, sir. General Clauses Act is mainly for interpretation and central legislation. That is what one of the question is there. I answer that. Second question is, internal rates are specific words mentioned. Okay, this is a comment. Okay, it is fine. And then we are having, is there anything? Okay, fine. So there are no questions. These are just comments. Thank you for these comments. I now let us move ahead and talk about a very important provision which leads to interpretation and exercise, that is Constitution of India. Now, Constitution of India, or Article 13, defines law, right? So when we are discussing with General Clauses Act or otherwise the laws, we are trying to have a look at the laws in force. So Article 13 provides a detailed understanding of this. So let me take you there. Article 13, subclause 1 tells that all laws in force in the territory of India immediately before the commencement of this constitution, insofar as they are inconsistent with the provisions of Part 3, that is fundamental rights, shall to the extent of such inconsistency be void. So basically, it is trying to say that any law enacted in the country which goes against the principles of fundamental rights, that is considered to be void. However, fundamental rights are not absolute. You people are aware there are reasonable restrictions to that under 19 subclause 2. So you will be having a look at that interpretation accordingly. However, Article 13(2) says the state shall not make any laws. So it is trying to say two kinds of things. One is if there is some law which is made already and it is inconsistent with Part 3 of the Constitution, that is fundamental rights, it will become void to that extent. Second, it gives an obligation on the state that they should not make any law which is abridging or breaching the fundamental rights of the people. Okay. Now, 13(3) defines law, and it defines law by stating that in this article, unless the context otherwise requires, the term law includes ordinances, orders, bylaws, rules, regulations, notifications, customs or usages having the force of law in the territory of India. So you can see here, there are different terms which are used. Ordinances, they are also laws. Orders, they are also laws. Bylaws, they are also laws. Rules, regulations, notifications, these are all laws. So it cannot be said that only the act of parliament is law and a rule which is made under the act of parliament is not a law, right? So the all kinds of law, including rules, regulations, have to conform to Article 13. That cannot breach any established fundamental rights under the Constitution of India. So laws in force includes laws passed or made by the legislature or other competent authority in the territory of India before the commencement of the constitution. So this is talking about the pre-constitutional laws. So I'm not going into the details of it. I just want to underscore here that laws does not always mean the act of the parliament. It can be even delegated legislation. And this is an important point which you should keep into mind. I will talk about delegated legislation in a while. Let us now look at a concept of immovable property. Okay, this is quite an interesting and flows from the application of General Clauses Act. So immovable property, whether fish is an immovable property. What do you think? It is an movable property or an immovable property? Yes. What do you say? Movable property, okay. Some people are saying it is movable property. Fish is a movable property or immovable property? Movable. Okay. Okay. Very good. All of you say that it is a movable property. Mhm. Okay. Okay. Fish is a movable property. What is right to fish, what do you think? Whether it is a movable property or an immovable property? Yeah, your responses are quite interesting. Huh? It can be transferred easily, so it is a movable property. Yeah, it gets transferred easily also, so it is a movable property, right? Whether it is a movable or an immovable property, most of you have said movable, probably by the nature of looking at the fish as the nature of, nature of the fish to move from one place to another. Okay. Someone says immovable property. Okay. So, yes, Miss Ria, you are saying immovable property. Let us look at that, and that is where okay, right is immovable. So you got it. So basically, if you see immovable property, so that is where application. We are trying to understand the application of General Clauses Act. Okay. So, if you see here, Section 3 of the Transfer of Property Act does not define the term. The main question is that. So, where do you go to find whether movable or immovable? You go to the Transfer of Property Act. So, Section 3 does not define the term immovable property, except to say that immovable property does not include standing timber, growing crops, or grass, right? So, it is basically saying that if there is a tree which is standing on a piece of land, that is not immovable property because it can be cut. Similarly, standing timber or growing crops or grass. A fish do not come under this category. So fish is not a growing timber or maybe a standing timber or grass. It is a movable thing, as you just now all of you said. So the definition in the General Clauses Act applies. And if you look at the General Clauses Act definition, you will find the Section 3 subclause 26 of the General Clauses Act 1897 reads as under. It says, immovable property shall include land, and it says benefits to arise out of land and things attached to the earth or permanently fastened to anything attached to the earth is an immovable property. So this is a very important definition for taxation purposes also and for all other purposes. So here you can see here, fish is considered as a profit a prendre. That is a legal right allowing a person to extract something of value from others' land and is regarded as a benefit arising out of the land. It follows that it is an immovable property within the meaning of the Transfer of Property Act. So under the Transfer of Property Act, fishing or right to fish is basically a immovable property. And this has been held in Anand Behera versus State of Orissa 1955 2 SCR 919. So fishing rights are immovable property. Similarly, mining rights are an immovable property, though you can mine and take away coal from that particular mine, but that is an immovable property. So this is how the interpretation applies, right? So fishing rights across the country, you will find that there are pattas given, and that is everywhere state gives that particular patta, or you can say the right to fish, and that is an immovable property. So quite an interesting example to look at from the perspective of General Clauses Act application. Thus, the court construed right to catch or carry fish as an immovable property. Now let us look at the application of General Clauses Act. So application of General Clauses Act, this act may be called the General Clauses Act 1897. And as I told you before that this law applies only to the central legislations, not to the state legislations. So application clause you will find in multiple legislations. Every legislation has got application clause. However, in this law, you don't find that application to a particular state is excluded. Like, for example, if you see, I have given an example of Bharatiya Sakshi Adhiniyam. It will find, it says the act may be called the Bharatiya Sakshi Adhiniyam, and then it applies to all judicial proceedings in or before any court, including court martial, but not to affidavits presented to the court or officer, not to proceeding before an arbitrator. This is an exclusion under the Bharatiya Sakshi Adhiniyam, that is Indian Evidence Act. It shall come into force on such date as the central government. So this is an example of short title application and commencement. However, in General Clauses Act, you don't see the term application and commencement. There is only short title, right? Because there is no provision of application and commencement there. This is a distinction between General Clauses Act and general laws. General Clauses Act also applies for interpretation of the Constitution of India. So you will find under Article 367 of the Constitution of India, it authorizes use of General Clauses Act for interpretation of the Constitution of India also. So why it is important? Because you see, General Clauses Act is a pre-British era legislation. But when our constitution was enacted, after the constitution came into force, Article 367 specifically said, unless the context otherwise requires, the General Clauses Act 1897 shall, subject to any adaptations and modifications that may be made therein, under Article 372, apply for the interpretation of this constitution as it applies for the interpretation of an act of the legislature of the Dominion of India, right? So law applies to also constitutional interpretation. The General Clauses Act generally applies to all kinds of legislations. However, in your study material, there are three types which are mentioned. Acts of the Indian Parliament. So any law which is passed by the Indian Parliament, General Clauses Act applies. Second, acts of the Dominion legislature. When you talk about Dominion legislature, we are talking about British era legislation. Second, third, act passed before the commencement of the constitution by the governor. So there was a period between independence and commencement of the constitution, 2-3 years. So the laws which were passed during this particular period are also covered under the application of General Clauses Act. Now we move to the structure of legislation, some basic understanding of legislation. And in this, I have taken the example of Digital Personal Data Protection Act, for which the rules have also been notified. You people must be aware about it. Recently, I think 2-3 days back, the rules have also come up. But you can see here in this legislation, on the top, you are finding the Gazette of India, the Bharat Ka Rajpatra. So all legislation which gets notified or passed by the parliament gets published into Gazette of India. And there is a particular numbering system of that. I'm not going into the details of it. But for you, whenever you are looking at the legislation, do focus on certain things. One of the focus is date of publication of the Gazette or Act in the Gazette. So generally, this is the date of the legislation on which the Act has been passed. This is called date of publication of the Act in the Gazette. Then you can see down, go down and have a look at it. It says Ministry of Law and Justice, Legislative Department, and then New Delhi. And then you can see there is a date. And then there is a date when President gave the assent to the legislation. That is when the President actually gave a assent to the legislation. You must be all aware that law becomes, law becomes law only after the President gives the assent to that or permission to that. So you can see also the title of the law, that is Digital Personal Data Protection Act 2023. And you can also see in bracket, there is something written that is called number 22 of 2023. So every legislation gets a number in that particular year. So this was the 22nd legislation of 2023, which was passed by the parliament. Now you can see here, there is in the law, you will find there is a preamble. So preamble is an act to provide processing of so-and-so, and that is preamble. So it sets the context of the legislation. And then you can see here, there is a short title and commencement. So short title of the legislation is Digital Personal Data Protection Act. This is the short title of the law. Long title, as you can see here back, it includes even the number and all those things. So this is the difference between that. And then commencement and extent of application. So as I told you before, that law may not immediately commence. There may be laws which commences in parts. There may be future date with which it is said that law will come into force on so and so date. So commencement and application, extent of application is very important. So this law, that is DPDP Act, you can see, you can read that it shall come into force on such date, and as the central government may by notification in the official gazette appoint, and different dates may be appointed for different provisions of the act, and any reference in such provision to the commencement of the act shall be construed as a reference to the coming into force of that provision. So it basically says that whole legislation is not required to be coming into force immediately. It may come into force in parts. So that is what it is saying. And every time a delegation is given here to the central government, it may notify the law to be applicable from X date or Y date. So that is called notification. So these notifications will be coming later. Then in a legislation, generally you will find a definition clause, which is basically an internal aid to construction also. So these are all internal aid to construction because they are part of the legislation itself. So you can see here there is a definition clause, and this definition clause tells you about different definitions which is there of the part of the legislation. Now here I would like to underline one thing. You see a definition clause in General Clauses Act, and you see a definition clause here in the statute or the legislation. Generally, the definitions which are there in the General Clauses Act will not be mentioned here in the specific legislation. But suppose there is a legislation wherein there is a definition which is provided. So always the definition under the statute or the legislation will get precedence over the General Clauses Act. Because General Clauses Act only you will refer after you do not find the meaning in the legislation. Say for example, there is a word which is defined in Digital Personal Data Protection Act, and that is also having a definition which you find in General Clauses Act. So you have to prefer the definition which is given under the statute, not the General Clauses Act. When you don't find a meaning of a word, then you look at the General Clauses Act and try to find out whether that definition is there or not. So this is what is a distinction between the definition clause of a statute and definition clause of a General Clauses Act. So if there are many words which are not defined in the definitions of the Act, the meaning of such words may be taken from the General Clauses Act. Like, for example, let us have a look at it. Clause 95 of Section 2 of the Companies Act clearly says that. Now, this is another important, instruction with reference to definition. Many a times, the statute itself refers to similar statutes for definition. Like, for example, under the Companies Act, you will find that Companies Act refers to, after the definition clause, it refers to Securities Contract Regulation Act 1956, Securities Exchange Board of India Act 1992, and Depositories Act 1996. These are the legislations which are referred to in the Companies Act to go back to find out what is the definition. So definition will be, for interpretation of Companies Act, what is the sequence you will follow? First, you will see the definitions under the Companies Act. If you don't find a definition in the Companies Act or there is a confusion, you will go and have a look at SCRA, you will have a look at SEBI Act, you will have a Depositories Act. Still, if you have confusion, you will go to the General Clauses Act. This is how the interpretation is, and this is how the you have to proceed with interpretation. So you can see here, the General Clauses Act is a last resort. You always go to General Clauses Act when you don't find anything anywhere. Go to the General Clauses Act for guidance. If you don't get any guidance on General Clauses Act also, when courts are there, court will provide the guidance, and that will be the interpretation of the law, or you can say construction of the law, which will happen. Now, there are some delegated legislation as well. But before I move on to the delegated legislation, let me, check any questions. Yes. So there is a question whether this Odisha case is applicable to entire India. So Mr. Hussain, this case was decided by Supreme Court of India, and hence it is applicable to all over India. Many a times, if you don't have a precedent by Supreme Court of India and it is decided by one of the high courts, it is persuasive value. So say, for example, you are in Delhi or Punjab and Haryana, and there is an issue on which you don't have a decision by Supreme Court and you have a decision by Odisha High Court, then you can always put that case before the court saying that the, such and such high court has decided. Court may agree, may not agree, right? So this is how we go ahead with the interpretation. This is the rule of stare decisis. Now, each law specifies its own definition. Yes, every law generally will have a definition clause because nowadays legislations are very bulkier, and there are chances of confusion, right? So for example, there is a term which is there in a commercial legislation may have a different meaning, and that same term in a taxation legislation may have a different meaning. And hence, it is important for you to have a look at it. I can give you an example. For example, resident in India or a resident in India is defined in taxation statute in a different way. In a FEMA, that is Foreign Exchange Management Act, the definition is in a different way. So you have to refer to the definition, and hence every law has got its own definition. Okay. Okay. So this is I will answer this question, Kuldeep, in my break time. It relates to codes and laws. When we talk about codes, basically codes are consolidation of laws. That is what is referred to as codes, and laws are individual laws. So why they are called codes? Because they have consolidated multiple legislation. So in previously, if you will see, there were more than 44 or so labor legislations which have now been consolidated into 4 codes, and that is why it is referred to as codes. So it is called codification. That is why. I hope that answers your question. I thought that I will answer it because maybe I'll miss it. Okay, now let us look at delegated legislation. So when we talk about delegated legislation, every law has got delegated legislation power. So whichever legislation you look at, towards the end of the legislation, you will find some powers given in the legislation. As here in this case, you can see here, there are 3 sections which I have highlighted in DPDP Act. Generally, in legislations, you will find similar kind of provisions. Like, for example, Section 38 in this, you see it says consistency with other laws. So there will always be a general rule of interpretation says that general laws have to give way to these special laws, right? Like say, for example, we have got Evidence Act. Evidence Act has to give way to a DPDP Act if there is a particular clause or definition given there. Okay. Similarly, Contract Act has to give way to the Companies Act. Companies Act has to give way to the Insolvency and Bankruptcy Code. Why? Because Insolvency Bankruptcy Code is a specific legislation on commercial insolvency. Companies Act is a general legislation on commercial laws or corporate laws. Am I making sense to you? So this is what this provision says. Another important thing which it is saying is that later laws will also prevail over the previous laws. However, Section 38 says that there should be a harmonious construction of laws. So you can read the provision. It says the provisions of this act shall be in addition to and not in derogation of any other law for the time being in force. So you have to read them together. So it does not mean that DPDP Act has come up, so all other legislation will go away or they will have no relevance, right? And then further it is saying in event of any conflict between the provision of this act and provision of any other law for the time being in force, the provision of this act shall prevail to the extent of such conflict. So there is a specific mandate which is mentioned that if there is a conflict between these 2 legislations, say for example, Contract Act and DPDP Act will prevail over Contract Act. This is what this provision means. Another important provisions nowadays you will find in modern legislation is bar of jurisdiction. So generally the laws will bar a civil suit. So they will say that, okay, civil court will have no jurisdiction because these legislations provide for special courts. Like for example, company law, we are having NCLT. So there is a bar of civil jurisdiction. There is no requirement to go to the civil court. Similarly, IBC, there is a bar of civil jurisdiction. Similarly, here, civil court will have no jurisdiction unless the board, which is there in that particular law, is empowered to move to civil court on certain situations. Okay. Now let me come back to my delegated legislation point. That is power to make rules. So you can see here, Section 40 talks about power to make rules. So central government may, by notification, and subject to the condition of previous publication, make rules not inconsistent with the provisions of this act to carry out the purposes of this act. In particular, and without prejudice to the generality of the foregoing power, such rules may provide for any of the following matters. As you can see here, central government is empowered to make rules on certain matters under the legislation. So, power is derived from where? From the parent act. So, central legislation gives them the power to make them rules. Similarly, there is power to make regulations. Delegated legislation also talks about power to make regulations. And Ministry of Corporate Affairs in this particular case is having, sorry, not Ministry of Corporate Affairs in this case. In Companies Act, Ministry of Corporate Affairs is there. Insolvency and Bankruptcy Code also, Ministry of Corporate Affairs is there. And there are certain powers to make regulations. Like, for example, the boards like IBBI is having power to make regulations. Power to make rules is always with the government or the ministry, you can say the nominated ministry as per the, allocation of business rules, and regulations by the respective regulator. So this is how the delegated legislation works. NFRA, National Financial Reporting Authority, has also got power to make regulations. I think a number of regulations which have been made by NFRA applies to the CA profession. So you people must be aware about this regulator, new regulator now for you people. So there is an additional new regulator, I must say, because ICAI is always a regulator for the CA professionals. But there is an oversight mechanism now by National Financial Reporting Authority. So that is another legislation which is there for you. So any question till this point? The general perspective, I would be happy to answer any one of you. Any questions or any clarifications till this point? Okay. No, but what is the struggle, Mr. Anil, on your question? I'm not getting your question. If you can elaborate a bit. General Clauses Act, as I told you, the legislation, you have to have a look at all the legislation first, whichever legislation you are dealing with. You have to see that particular legislation, try to find out answers there. If you are not able to find any answer there, then you have to move ahead and go and to the General Clauses Act. This is what I've said. Okay. I hope that is fine. Okay. So not to worry, I will be sharing this particular PowerPoint presentation in your portal, the portal which you people are having. There it will be shared. So don't worry. This is a resource material. You may not be finding everything which I am talking here in your study material, because this particular topic requires a bit of a elaboration, because everybody from you is not from the law background. You are not formally trained in law, and hence it is important for you to get this context. It will be easier for you to understand the General Clauses Act if you have this context. Okay. I hope this answers your points and queries. Let me move ahead and talk about the commencement. Okay. So section 5 of the General Clauses Act talks about commencement, or you can say general rules of construction coming into operation of enactment. So if we read the provision, okay, let us move ahead and talk about that. And we say, where any central act is not expressed to come into operation on a particular day, then it shall come into operation on the day on which it receives the assent. Assent of whom? It is talking about two things. Okay. One, in case of a central act made before the commencement of the constitution of the Governor General. So now this is not applicable. We don't have a system of Governor General now. But you may be wondering why this provision is there. This provision is there because it was General Clauses Act came before we had constitution, right? So that is why this provision exists. Now may not be of very necessity. The clause B is important for you. In case of an act of parliament, the president. So whenever the president gives the assent, the law will come into force. However, clause 3 is important. Okay. Clause 2 is deleted here. Clause 3 is important. It says, unless the contrary is expressed, a central act or regulation shall be construed as coming into operation immediately on the expiration of the day preceding its commencement. This is quite an interesting one. Okay. In all these scenarios, there is a presumption against retrospectivity. So generally the laws will be prospective. They will not be retrospective, right? So all laws generally will be prospective, which will apply for future, not from the back date. So Supreme Court in A.K. Roy versus Union of India, that is a 1982 case, observed that where an act empowers the government to bring any provisions into operation on any day which it deems fit, no court can issue a mandamus with a view to compel the government to bring the same into operation on a particular day. It is quite interesting. Okay. So can court say that, okay, bring this law into operation immediately? This is a, question. Like, for example, recently you would have seen there are petitions which were filed in the Supreme Court about, seeking mandamus for applying the Women Reservation Act. So they said that, okay, fine, can an order be issued? The court said that, see, we cannot issue an order or direct the government to immediately implement a particular law, because it is the legislature's job to come up with the date when the law will be coming into force, because there are multiple things which surrounds a legislation's interpretation and application. Okay, I hope this clarifies. Let us give you the examples. There are two examples. One, this is coming from your book. The Companies Act received assent of President of India on 29th August 2013 and was notified in Official Gazette on 30th August 2013 with the enforcement of Section 1 of the Act. Accordingly, the Companies Act came into force enforcement on the date of its publication in the Official Gazette. So you get the force. The law came into force on 30th of August 2013 when it was notified. Okay, when it was notified for the information of all the public. SEBI issue of capital and disclosure requirements 5th Amendment Regulation 2015 was issued by SEBI wide notification dated 14th August 2015 with effect from 1st January 2016. So you can see here, this was a prospective application. So the law, though it was notified on 14th August 2015, it itself said that the law will come into force on 1st of January 2016. Here, this regulation came into force on 1st of January 2016 rather than the date of its notification in the Gazette. So you have to see, contrary to the provision, if there is something which is mentioned clearly, then that will be taking precedence over something which is not mentioned. Okay. Let us look at this particular problem. I would like to hear your views. So just read the problem. In 2025, the state legislature amends the Environmental Protection Act, increasing the penalty for illegal sand mining from 50,000 rupees to 5 lakh rupees. Raghav had engaged in sand mining in 2023 when the penalty was only 50,000. The authorities now impose the enhanced penalty by applying the 2025 amendment retrospectively. Raghav challenges the order. What is your view on this? I would like to listen. You can type it in your chat box, or you can, if you have permission, you can speak also. Okay. Can we have some responses? Raghav's challenge is right. Okay, but why? Okay, it is effect retrospectively. What is that? Like, because it is not to be retrospective. Yes, Navneet, very true. It is not to be retrospective. So this is the rule against retrospectivity. Okay. So there is always a presumption against retrospectivity, particularly with reference to penal statutes. There cannot be any retrospection. unless it is specifically mentioned in the law. Generally, if it is mentioned in the law, then there may be, but generally the law will be, prospective. It will not be retrospective. So in this case, what has happened? The amendment imposes a new and heavier penalty which affects substantive rights of Raghav. Okay. And substantive laws are presumed to be prospective unless the statute expressly states otherwise. There is no express intention for retrospective application. Retrospective operation would violate principles of fairness and legal certainty. So what is the conclusion? The enhanced penalty cannot apply to Raghav's 2023 conduct. So this is what it says. Okay. Very good. So you people have all got this particular concept, retro presumption against retrospectivity. So there is generally, in case of procedural laws, retrospective effect can be there. So procedural laws which does not affect any substantive right of the people, retrospectivity can be there. We will talk about this concept in repeals also in a while, so you will get more clarity. Okay. Now, moving ahead, there are some terms which requires a understanding when we talk about General Clauses Act. One of the important terms which you will find in legislation is means and include. So there are two kinds of definitions. One is restrictive definition and the other one is extensive definition. So legislature has all powers to define the word even artificially. Okay. So they can define the term artificially. It can, one example which I can give you is that under the Indian Penal Code, it says that wherever you find he, you interpret it as she, transgender, everything. Okay. So that is a legal fiction, or you can say a legal interpretation given in the statute itself. So the definition of a word in the definition section may either be restrictive or of its ordinary meaning, or it may be extensive of the same. So when a word is defined to mean such and such, the definition is prima facie restrictive and exhaustive. Whereas when the words defined and declared is include such and such, the definition is prima facie extensive. So whenever you find the word means, that means it is restrictive. Whenever you find include, that means it is broad. When by an amending act, if there is a law which is amended and you have replaced the word means with includes or includes with means, then it was held that intention was to make it more extensive. Further, a definition may be in the form of means and includes, where again the definition is exhaustive. So there are different interpretation of this particular term, but basic outline is that wherever you find means, that means you have to restrict the meaning. Wherever you find the word includes, you can be expansive meaning. So this was held in one of the cases, Delhi Development Authority versus Bholanath Sharma. Let us take some examples. These examples are there in your book. One, definition of company as given in section 2 subclause 20 of the Companies Act. It states company means a company incorporated under this act or any other previous company law. So what does it mean to you? It is basically a specific definition. You cannot include any other thing in the definition of the company. Similarly, section 234 of the Companies Act defines the term director. And it says director means a director appointed to the board of a company. So nobody else. So there is a concept of de facto director which has been taken away now. There is no concept of de facto director now after this definition. So the definition is very, very clear. Definition of a director means a director who is appointed by the board of a company. If someone is even discharging the duty of a director and is not appointed by the board of the company, he may not be considered as a director. This clarity has been given under the new company law. Let us look at another example. The word debenture is defined in section 2 subclause 30 of the Companies Act, and it states the debenture includes debenture stock, bonds, or any other instrument of a company evidencing a debt. So here you can see anyways, the word includes is used, and it further says any other instrument of a company evidencing a debt, whether constituting a charge on the assets of the company or not. This is a definition of inclusive nature. Similarly, there is another example, that is body corporate. So a corporation, body corporate or corporation includes a company incorporated outside India. So section 2 subclause 11 of the Companies Act defines this. And you can see here it includes incorporated outside India. So it can be an expansive definition, body corporate or corporation. So this is how you interpret the term means and or includes. Some of the examples, some more examples, we can have a look at it. Like 2 subclause 12 defines executed and execution. Used with reference to instruments means signed and signature, right? Similarly, 2 subclause 14 defines instrument, includes every document by which any right or liability is or purports to be created, transferred, limited, extended, extinguished, or recorded. 2 subclause 16 defines lease, and it says it means a lease of immovable property and includes also. So you can see in a definition there are two terms, means and includes also a patta, kabuliyat or other undertaking. So in the case of Nasiruddin versus state of Uttar Pradesh, the question came up that whether that transaction attracted stamp duty or not. So here the court interpreted the term includes and included the transaction as undertaking as a lease, and then there was a stamp duty imposed on that transaction by expansive definition. So this is how the interpretation helps. So in this case, that is Bharat Corp Bank versus Cooperative Bank Employees Union. Court said wherever the expression means is followed by expression and includes, whether with or without additional words separating means from includes, these expressions indicate that the definition provision is exhaustive as a matter of statutory interpretation. It has also been held that expression and includes is an expression which extends and definition contained in words which follows the expression means. So this is how the interpretation of the terms are being done. There are some more terms which I would like to discuss, but before I move on to that, I would like to take some questions or your points if you have before we take the break. So I'm just trying to understand from you any questions. If you have any questions, let me check the portal as well. Okay. Have any questions? I think there are no questions. Only 2 questions are there. Any questions? No. No. Yes. No one, no questions? Yes, any questions? Any one of you, if you have any questions, please ask. I don't know which, Kuldeep, I don't know which case you are referring to. In mining case, why 1982 case cannot be referred? Generally, cases, if they are decided by Privy Council, which is having a precedent value, can be always referred to. So we have to see in which context you are asking this question. Your question is not clear to me. So if you can please elaborate that further, I will be happy to answer that. Harsh, I don't know whether the cases are, important for you to remember. All cases names we all don't remember, but facts and related laws you should be aware. And probably you will get situation-based questions which you have to answer as per the law. That is how is the pattern for your examinations. Okay. Yes. Any more questions? Okay. 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 The case which you are referring to, this one. Okay. Just a second. Let me see. You are referring to this particular case, right? But where is the question of 1982 in this? We are talking about a situation where 2023 there is assigned mining and 2025. So we are not retrospective operation would violate the principles of fairness and legal certainty. So I am not getting what question you are asking. Kuldeep, can you elaborate now? Okay, fine. So I think it is clear now. Okay, good. Now we will talk about some modal verbs. Okay. Mhm. So modal verbs, you people must have studied in your grammar, right? Ren and Martin. I hope you remember. So modal verbs are helping verbs or auxiliary verbs, and they express the mood, attitude, or possibility of an action rather than the action itself. They show meanings such as ability, possibility, permission, obligation, advice, certainty, etc. And there are many modal verbs, right? So if you see, there are modal verbs can, could, may, might, must, ought to, shall, should, will, would. In our law, you will find may and shall to be used multiple times in many of the legislations. And there is a lot of confusion also around that. So if you see the plain aspect, it says the word shall is used to raise a presumption of something which is mandatory or imperative, while the word may is used to connote something which is not mandatory but is only directory or context of the word shall and may. So wherever you find the word shall, it raises a presumption of something which is mandatory. Okay. And wherever you use the word may, it connotes something which is not mandatory but only a directory. However, sometimes the word may and shall can be interpreted interchangeably depending on the intention of the legislature. Now, this is a tricky situation, So, many a times you will find courts look into it and tries to find whether may is shall or shall is may. I can give you one example. One of the provisions under the New Companies Act gave or under the Insolvency Bankruptcy Code gave a mandatory situation and instead used the word shall, that all the cases relating to insolvency and bankruptcy code shall be decided within 330 days, right? Now, when he says shall, that means it is mandatory. However, court interpreted this and said that here the courts cannot be mandated to do a thing in particular way in particular days, and it read that particular shall as may. Okay, so similar kind of a situation arises. A number of cases are there. One of the cases which I am referring to here is Dinesh Chandra Pandey versus High Court of Madhya Pradesh, 2010 case. And this is to explain you where may and shall can be interpreted and how it can be. So the court said in this, in paragraph 15, that the courts have taken a view that where the expression shall has been used, it would not necessarily mean that it is mandatory. It will always depend upon the facts of a given case, the conjunctive reading of relevant provisions, along with other provisions of the rules, the purpose sought to be achieved, an object behind implementation of such a provision. So as you can see here, this is a bit complicated. So it is not the plain meaning. You are trying to look at the conjunctive reading of relevant provisions along with the provisions of rules, purpose for which the law has been brought, object behind the implementation of the provisions. This court in Sarla Goel versus Krishan Chand, this is another decision which court is referring to, took the view that the where word may shall be read as shall would depend upon the intention of the legislature, and it is not to be taken that once the word may is used, it per se means on the face of it would be directory. In other words, it is not merely the use of a particular expression that would render a provision directory or mandatory. It would have to be interpreted in the light of the settled principles and while ensuring that intent of the rule is not frustrated. So you can see this is a bit of a complicated matter as to how shall and may be interpreted. So this is the context with which I am, putting a break here now. I think we are here at 7:16 already. So we take a 15-minute break and we meet at 7:36. So, and after that, we will continue with the session. In the meantime, if you have any questions or clarifications, please feel free to be, uh, asking with that particular question. Okay. We take a break here for 15 minutes. welcome back. Are you there? All of you, welcome back. Let us continue our discussion. So we were discussing about shall and may. Okay, this is the interpretation which we were discussing. And now let us move ahead and talk about this shall and may, some examples which are there in your booklet or reference material. So one of the example 14, it talks about section 3 of the Companies Act states that a company may be formed for any lawful purposes by, okay. Here the used may shall be read as shall. Okay, usage of word may here makes it mandatory for a company for the compliance of section 3 of its formation. So you can see here the word used is may, but it is read as shall. So because company cannot be formed for any other purpose than a lawful purpose, right? So it is maybe this particular word may is read with may be formed. Okay. So a company may be formed or may not be formed. But whenever a company will be formed, it has to be formed for lawful purposes. So here the term may is mandatory in a sense of the term, right? So example 15, it says section 21 of the Companies Act provides that documents, proceedings requiring authentication or any contracts made by or on behalf of the company may be signed by any key managerial personnel or an officer of the company duly authorized by the board in this behalf. Now, usage of may shall be read as may. In this particular situation, there is no requirement of a shall. It is saying may. So it is may be signed by key managerial personnel or an officer of the company. So there is a discretion given. It is not a shall that it has to be signed by key managerial personnel only or X person only. That is not there. So it is mentioning that key documents may be signed by authorized representatives. So this is the difference. Now let us talk about and discuss something more. So ordinarily, when we talk about may, the word may is directory in nature. The expression may admit confers discretion to admit. In contrast, the use of the word shall postulates a mandatory requirement. The use of the word shall raises a presumption that a provision is imperative. However, it is well settled that prima facie presumption about the provision being imperative may be rebutted by other considerations such as scope of the enactment, the consequences flowing from the construction, etc. So, on the face of it, prima facie, if you are not interpreting it, may would mean directory and shall would mean mandatory. However, by way of an interpretation, by looking at the context of the legislation, by looking at the premise of the legislation, the object of the legislature, you define whether this is may or shall. Let us look at another provision of IBC to understand this better. So, legislature has in its wisdom used the word may in section 7(5)(a) of IBC in respect of an application of CIRP initiated by the financial creditor against a corporate debtor, but has used the expression shall in the otherwise almost similar provision under section 9 subclause 5 relating to initiation of CIRP by operational creditor. So we can see there is a distinction between operational creditor and financial creditor. The fact that legislature used may in section 7(5)(a) of the IBC, but different word, that is shall, in otherwise almost identical provision in this, shows that the two provisions are intended to convey a different meaning. And it is apparent that legislature intended this to be mandatory and this to be discretionary. So this is in the context of the notice, right? So there is a requirement of a notice and there is a requirement of not a notice. So in case of operational creditor, there is always a requirement of a notice because the shall word is used. Whereas in case of financial creditor, may word is used. So it is discretionary. However, over a period, by way of an interpretation, this may has been, looked into and they have tried to say that, okay, fine, you need to have a notice. That is a different thing. But this interpretation was there in Vidarbha Industries Power Limited versus Axis Bank Limited on 12th July 2022. So you can see here how the meaning of may and shall is interpreted by the courts. Now we will move ahead with the General Clauses Act, preliminary section 1. And if you see preliminary section 1 of the General Clauses Act, it says this act may be called the General Clauses Act 1897. Right. Preliminary is the introductory part of any law, which generally contains short title, content, extent, commencement, application. This I have already shown you before in one of the legislation. If you recollect, Bharatiya Sakshi Adhiniyam, I showed you. The title, although the part of the act in itself, not an enacting provision, every act is given a title to carve out its own identity, just like people are given their names to identify them. This comes directly from your course material. General Clauses Act 1897 contains only short title in preliminary part of the act, and section 2 of the General Clauses Act has been repealed because it is a repeal section itself, which is of no use now, so that has been repealed. General definitions. This is an important section of the General Clauses Act because there are multiple definitions and each of these definitions are used for interpreting the different terms. And if you have a look at section 3, talks about this, and it says in this act and in all central acts and regulations made after the commencement of this act, unless there is anything repugnant in the subject or context. So wherever you find this particular term, anything repugnant in the subject or context, that means what? Repugnant means contrary to. So anything which is beyond the subject or a context, and that is why I always emphasize on the point, subject is the king, context is the king in terms of definition. So it will mean what has been the definition or the meaning which has been provided here. So see here, section 3 subclause 2 defines act, and it says act with a capital, right? So act is a homophone here. So act, ACT, act means action also, ACT, act means law also. So here ACT is the law, and it says act used with reference to an offense or a civil wrong shall include a series of acts. So you can see here a series of acts and words which refer to acts done extended also to illegal omissions. So here this ACT act is not the legislation, it is the action which is there. So here the definition 3 subclause 2 defines the act as an action, and it says act used with reference to offense or a civil wrong shall include a series of acts. So it is not only a single act, but a series of acts, and the words which refer to the acts done extend to even illegal omissions. So act is not only positive, but even an omission will be considered as an act. So this is what is the definition of the term act here in this particular case. Now, 3 subclause 3 defines affidavit, and I have tried to categorize the definitions into one section. So you can see here we have included subclause 37 and 62 also here because they are related concepts. So I have tried to give you the concepts in one bucket so that it becomes easier for you to understand. So first thing which we discussed is with reference to the action or omission, which has been defined as an act with reference to civil or a criminal wrong or offense. Okay. Section 3 subclause 3 defines affidavit. You all must be heard the word affidavit many a times, and affidavit has got different connotations. So if you see the word affidavit, the definition goes like this, and it says affidavit shall include affirmation and declaration in the case of persons by law allowed to affirm or declare instead of swearing. There are two kinds of thing here which has been used. One is called affirmation and the second one is called swearing. So whenever you use the word swear or swearing, this has further been defined. If you see subclause 62, swear is defined, and it says swear with its grammatical variations and cognate expressions. What is the term cognate expressions? The term cognate expressions means similar expressions or grammatical variations or cognate expressions shall include affirming and declaring in the case of persons by law allowed to affirm or declare instead of swearing. So there are two modes by which you can write the affidavit. People who are religious people, who are believing in a particular book, like for example Bible, Quran, or Gita, these people will be doing swearing in the name of the God. But there are people who are atheist or who doesn't believe in swearing. They will do a affirmation or declaration. So they do an affirmation and declaration. That is the difference between swearing and affirmation, or affirmation and declaration. Then there is a definition of oath. So section 3 subclause 37 defines oath, and it says oath shall include affirmation and declaration in the case of persons by law allowed. This term is also very important. In the case of persons by law allowed. So who can affirm, who can swear? These are the people who are by law allowed to affirm and declare, right? So everybody is not allowed to affirm. Like for example, a minor cannot affirm, cannot declare. They cannot enter into an oath. So one has to be major. One has to be major. One has to be fulfilling all requirements of swearing an affidavit. Then only they can do it. Age is one of the requirements. You can say citizenship may be one of the requirements. They are only allowed to affirm. So this is how these three terms can be read together. Oath, you all know, oath is taken by people in office. Like for example, today the 53rd Chief Justice of India, Justice Suryakant, took the oath of the Chief Justice of India office. So oath is, and he did that. I have not heard the oath completely, whether it was affirmation or swearing in, but you can always listen to that and find out whether it was swearing in or affirmation. So affidavit can be affirmed or it can be sworn, right? So I hope this thing provides you a bit of a clarity on affirmation and oath and affidavit. Subclause 35, section 3, subclause 35 defines month, year, and financial year. These definitions are provided in General Clauses Act. You will find that these are definitions in subclause 35, 66, and 21. Though they relate similar, they are having different numbers and quite far away. So you can see the definitions in the definition clause is arranged alphabetically, right? So it is not by way of their affinity to the terms or closer terms are kept together. It is by way of a alphabetical order. So here you see month. Month shall mean a month reckoned according to the British calendar. So what we are using British calendar. Year shall mean a year reckoned according to the British calendar. Financial year shall mean the year commencing on the first day of April. This is what is General Clauses Act. Now, I don't know how many of you follow the Banking Regulation Act. Probably the new Banking Regulation Act has changed this definition from, I think we have utilized our year, financial year, starting from April or something. That change, you can all track it, and maybe we can keep it for the next class where I can discuss this in a much detail. But you can see here, for everything, there is a definition. What is a month? What is a year? What is a financial year? This is the definition which has been provided in the General Clauses Act. Let us move further. Nothing much to deliberate upon this. These are quite simple definitions which you are able to see here. You have to refer to British calendar. And then central government. Okay. So there is a law. Basically, if you will see the applicability of this particular law we are looking at, and it says the central government shall. It is talking about two kinds of legislations. Okay. One is before the coming up of the constitution and one is after coming up of the constitution. So it says central government shall, in relation to anything done before the commencement of constitution, mean the governor general. So it is trying to tell you that who was central government before constitution and after constitution. So before constitution, before the Constitution of India came into force, reference to the central government was to the reference to Governor General and Governor General in Council, as the case may be. And after the commencement of the Constitution, it means President of India. And in relation to entrusted 252 Constitution of the state government and its acting authority. So this is what they are talking about. They are also talking about the after the Constitution of India, they are discussing about the different parts of the state. So it's saying in relation to the administration of Part C state before the commencement of the Constitution, the Chief Commissioner or the Lieutenant Governor of the government of a neighboring state or other authority acting within the scope of the authority given to him. And in relation to administration of union territory, the administrator thereof. So basically, it is telling that who is in authority, who is the central government at that point in time. This has been discussed. So this particular slide, you can see part A, B, and C and D states have been categorized. So you can see here, part A states are former British provinces, that is 9 states, Assam, Bihar, Bombay. So this is for your academic knowledge. You can have a look at it. I don't think that you will get any question on part A, B, and C, D kind of a thing. So you just have a look at it. This is for your knowledge and understanding. By the way, November 26th is round the corner. We will be celebrating National Law Day when Constitution was, enacted, and we all, read the preamble on that particular day. So this is the week actually. So this information you can read more and try to understand how it operates. 23, we are discussing this in the context of 23, and it says government or government shall include both central government and any state government, right? So we saw the definition of central government. We saw the definition of government or the government shall include both central government and the state government. Now, 3 subclause 7 defines central act, and it says central act shall mean an act of parliament and shall include an act made before such commencement of Governor General and Council. So you can see here, we are talking about the central legislation prior to the Constitution, after the Constitution, and at the time of the Dominion legislature. This I have given you the categorization, 3 categorization in your work, in your book is also there. Then there is a definition of Indian law. So subclause 29 defines Indian law, and it says shall mean any act, ordinance, regulation, rule, order, bylaw, or other instruments which before the commencement of the Constitution had the force of law in any province of India or part thereof or thereafter has the force of law in any part A, part C of the states or part thereof, but does not include any act of parliament of the United Kingdom or any other council. So you can see our definition, Article 13 of the Constitution of India, I just referred to in my beginning. You can see that also utilizes the term ordinances, regulation, rule, order, bylaw, notification. Other instruments, here the term other instruments is used. They are very specific notifications, etc., etc. So this Indian law definition is provided accordingly. However, you can see this Indian law definition excludes any act of parliament by the United Kingdom and or order in council, rule, or other instrument made under such act. So Indian law means passed for India, not for British. Okay. Then there are other definitions, like for example, 319 defines enactment, and it says enactment shall include a regulation as hereinafter defined and the regulation of the Bengal, Madras, or Bombay Code, and shall also include any provision contained in any act in such regulation as aforesaid. Right? Section shall mean section of the act or regulation in the words or in which the words occur. So here again, I will draw your attention on the term act. Here A is capital, right? In our previous thing, we have seen act, we are referring to action where A is small. Subsection shall mean subsection of the section in which the words occur. Rule shall mean rule made in exercise of power conferred by the enactment and shall include a regulation made as a rule under any enactment. Schedule shall mean schedule to the act or regulation in which the word occurs. So you can see any legislation is arranged into section, subsection, and there is rule making power under which the rule can be made, and then there is a schedule, right? Commencement. So this commencement clause is very important, and 3 subclause 13 talks about commencement, and it says commencement used with reference to an act or regulation shall mean the day on which the act or regulation comes into force. So act, when it comes into force, when it gets power to be enforced, when it has got the power to be enforced. I can give you an example. Like, for example, we had Competition Act when it came into force. So if you will see the initially the law got its assent in somewhere 2003 itself. However, the practical provisions, that is section 3 and 4, got only notified on 20th May, 2009, if I am not wrong. And that is the time when the law actually came into force. If you see, the combination provisions under the Competition Act came only in June, 1st June 2011. So these are the different dates on which the act commences or the law commences. So this is called commencement. Official gazette, we have already seen official gazette or gazette shall mean the Gazette of India or official gazette of the state. So there are two kinds of gazettes. One is gazette published by the government of India, and the another gazette is published by the states. Then there's a definition of a document. Document is defined, and document includes any matter written, expressed, or described upon any substance by means of letters, figures, or marks, or by more than one of those means which is intended to be used or which may be used for the purposes of recording the matter is referred to as a document. So you can see document shall include any matter written and expressed. So it is not necessary that document has to be always on a piece of paper. A document can be on a digital drive. A document can be on what you can say, a parchment of leaf, or maybe a paper, or a document can be even a utensil on which something is written. So document can be anything. Medium doesn't matter. What matters is there should be some matter which is recorded by way of a written expression and by way of a mark on that particular document, right? Expression referred to as writing. So wherever you find the word writing shall be construed as including references to printing. So writing does not mean that it has to be written by hand. It includes printing, it includes lithography, it includes photography, and other modes of representing or reproducing words in a visible form will be referred to as writing. So, say for example, with your finger, you put something on the sand beach, that itself is a writing. Okay, if it is recorded and somebody takes a picture of that particular sand where you have given your witness or written something, that is a document. Okay, I hope I give a good example for you to understand. Okay, now subclause 24 talks about government securities. But before we move on to government securities, let me pick up some questions if you have, so that we are able to answer that. Give me a second. Yeah. Okay, oath and affidavit are two different things, because affidavit is always sworn in on a piece of paper, and this kind of a document which you document it, notarize it. An oath is something which is taken in presence of an authority, and then after the oath you sign that particular document. So these are two different things. In affidavit you make a lot of declaration about facts and situations. In oath you are basically saying what you will be doing, or you are committing yourselves to an office, and you are taking oath by saying that you will not do you will do things in a particular way. That is the difference between oath and affidavit. Okay. Constitution Day. Okay, and sometimes WhatsApp and document evidence. Okay, so WhatsApp or SMS as the evidence is being taken by courts in different ways. And under the Information Technology Act, there is a requirement of a certification that the computer system has not been tampered with. So this is a different law altogether for treating WhatsApp and SMS as documents. Thumb impression is also a writing. Yes, thumb impression is definitely a writing, because that is a mark which is given. So it is a writing and it is part of the document. Okay. Yes. Now let us see if there are a few more questions. Okay, no more questions. If you have any questions till now, you can ask. 2 minutes for questions if you have. Otherwise, we will proceed with the definitions. Do you have any questions? Yes, generally penalty cannot be imposed with the retrospective effect, past date. Yes, you are right. Okay, now let me continue. And then if you have any questions, just put it in the chat box. Okay, let me check the portal also if anybody has a question. Okay, let us move ahead. So, subclause 24 talks about government securities. And if when you will be studying security law, you will be studying it in detail. But here in General Clauses Act, government security is defined as securities of the central government or of any state government. But in any act or regulation made before the commencement of the constitution shall not include securities of government of any part B state. So this is the definition of government security. It's not of much consequences for you. So just read it once. Immovable property. This we have discussed. An example also we saw 326. Fisheries rights case. So immovable property shall include land, benefits to arise out of the land. What is that referred to as? Can you quickly type in the chat box? I use that particular term. Benefits arising out of the land. It's called profit A. No. There is a term. Profit A prendre. So that is what we discussed. Profit A prendre. Right? So that is referred to as benefits arising out of the land and things attached to the earth or permanently fastened to anything attached to the earth. This is the benefits, okay, arising out of. Good, very good, Shamli. Now, let us move ahead and talk about another definition, and that is of movable property. So it says it shall mean property of every description except immovable property. So I am always fascinated by the definitions in law. Definitions in law are quite simple, right? So why there is a necessity of defining this? You see, movable property shall mean property of every description except immovable property. Now, what is immovable property? For that, you go to the definition of immovable property, right? This is how we define the laws. Now let us. This is similar kind of a definition. You find it in private company and public company. So what is a private company which is not a public company is a private company. What is a public company which is not a private company is a public company. Quite interesting. Okay. Now registered is defined. Registered says used with reference to a document shall mean registered in India under the law for the time being in force for the registration of documents. So there is a Registration Act of 1908. So all documents, when you refer to registration, that means any document which is registered by way of provisions under the Registration Act will be referred to as registered, right? Or maybe any other act. So for example, if there is a state legislation that provides for registration, then that legislation, okay? Person. Person shall include any company or association or body of individuals, whether incorporated or not. So definition of person includes artificial persons as well as association, even if it is registered or not incorporated. 22 talks about good faith. And it says, a thing shall be deemed to be done in good faith, where in fact done honestly, whether it is done negligently or not. So what is good faith? Good faith means that it has been done with a good intention, done with honesty. There may be negligence in doing that, but good faith is something which is a principle which is applicable for, most of the time government servants, we apply this. Offense shall mean any act or omission made punishable by any law for the timing in force is referred to as offense. Then imprisonment shall mean imprisonment of either description as defined in Indian Penal Code. Now I think it will require a bit of a change. So we can say Bharatiya Nyaya Sanhita. So this is what will be the change which will be coming up, but till now it has not come. Section 4. Section 4 talks about the certain terms which used to be there in previous enactments and how it will be applying to different situations, that has been talked about in section 4. And it goes and it says like this: the definition in section 3 of the following words and expression, that is to say affidavit, barrister, district judge, father, immovable property, imprisonment, magistrate, month, movable property, immovable property, oath, person, section, son, swear, will, year, apply also, unless there is anything repugnant to the subject, to the context, to all central acts made after the third day of the January 1868 and to all regulations made after. So these are the time period of General Clauses Act in different situations. So if you see, this brings me to the history of General Clauses Act. Okay. So if you see, the General Clauses Act 1897 was actually a consolidation of General Clauses Act of 1868 and General Clauses Act of 1887. There were two General Clauses Act prior, and they were all merged together, and then General Clauses Act of 1897 came into picture. And that is why these terms have been mentioned, that if you refer to 1887 Act or you refer to 1868 Act, those references have to be merged together and that will be taken into consideration. The main object of these acts, as mentioned in the respective preambles of 1868 and 1887 Acts, is to shorten the language used in the central acts as applicable in India. This is the preamble of or objects and reasons of these legislations at that point in time. So there was a gentleman, a law member of the Council of Governor General at that point in time, referred to as Mr. M.D. Chalmers. And M.D. Chalmers, basically the then law member in the Council of Governor General, while introducing the bill for 1897 Act, pointed in the council that the new bill was not intended in any way to change the existing law. So I hope you got the context of section 4. It is basically trying to include the meanings and expressions of particular words in two different General Clauses Act, which got merged and they came up with General Clauses Act 1897. The definition in said section of the following words and expression, that is to say abet, chapter, commencement, financial year, local authority, master, offense, part, public nuisance, registered, scheduled, ship, sign, subsection and writing, apply also, unless there is anything repugnant to the subject or context, to all central acts and regulations made on or after the 14th day of January 1887. So there are basically three periods, as you are able to see, right? There are three periods. Which are the three periods? One, 1887, 1868 to 1887, and then 1887 to 1897. So it is referring to the legislations which have been incorporated during this period, how you will utilize the interpretation to these particular laws. That is what it has been talking about, right? The you can read more about the statements and objects of reasons and try to understand what it is saying. But the object of the General Clauses Act was to consolidate the General Clauses Act of 1868 and 1887. Then 4A was included. After we got our constitution, 4A was included, and it says that how the laws will be applicable to Indian laws, right? So if we look at 4A, give me a second. Yes, 4A is came in 1950 after our constitution came into existence, and it says the definition in section 3 of the expression British India Central Act so and so, unless there is anything repugnant to the subject or context, to all Indian laws, will apply to all Indian laws. Basically, we are trying to extend the interpretation of General Clauses Act to the post-constitution or after the constitution any legislation which has come up, right? So if you see Constitution, Article 226 of the Constitution of India expressly talks about that when it says consolidated funds and public accounts of India and states right? Subject to the provision of Article 267 and to provision of so and so. It is talking about different terms. So it is basically saying that these words and expressions will be, um, applicable to the constitutional provisions, or after the constitution has come into force, all the legislations which will come afterwards will also be applicable to the the general clauses will be applicable to that particular legislations. Subclause 2 says in any Indian law, references by whatever form or words to revenues of central government or state government shall, on from the first day of April 1950, be constituted as references to Consolidated Fund of India. So they are referring that wherever in the British period, if you will see, they were referring to revenue of the British. But here, all references in any legislation to that revenue will mean to Consolidated Fund of India. That is what it is trying to say. And Article 226 defines Consolidated Fund of India. Now we are moving to another chapter, and that talks about general rules of construction. And general rules of construction, when I use the term, it basically says interpretation, or you can say analyzing the meaning of the rules, that what are the general rules of construction. So as you can see here in this section, it begins with section 5 and ends with section 13A, which is repealed actually. So we will talk about them one by one. Section 6 talks about effect of repeal, and it is important. So it says, where this act or any central act or regulation made after the commencement of this act repeals any enactment hitherto made or hereafter to be made, then unless a different intention appears. So friends, you must be seeing this particular term many times, unless the context otherwise, unless a different intention appears. This is basically a caveat given to understand that if the law says something different, you have to go ahead with the different interpretation. But if the law is silent, then you have to go with the interpretation or construction which is given in the General Clauses Act. This is what is the simple meaning of this term, unless a different intention appears. Here there are 5 situations which have been talked about, which is the effect of repeal under section 6. Let us look at these situations. The first situation, it is saying, revive anything not in force or existing at the time at which the repeal takes effect. So, repeal of a legislation will not revive anything which was not present at that point in time. Okay, so it will not bring up new rights. It will not bring up anything new which was not there prior to the repeal. This is first point. Second point is, affect the previous operation of any enactment so repealed or anything duly done or suffered thereunder. So it is not only the positive aspect, even negative aspect which has been done in the repealed legislation. Say, for example, a law gets repealed on X date. So whatever has been done in that particular law's operation, whether it is, some action taken, somebody has suffered some problem, that will not go away. Okay, that will be very much there. C talks about affect any right, privilege, obligation, or liability acquired. So it is talking about right, it is talking about privilege, obligation, or liability. These are the 4 things which it talks about. Acquired or accrued or incurred under any enactment so repealed will not go away. So that will be very much be there. Fourth, it is talking about affect any penalty, forfeiture, or punishment incurred in respect of any offense committed against any enactment so repealed. So it will also not go away. So say, for example, there was some offense which was there, later on that offense went away. So a person who has committed that offense when the law was existing, and he is under the obligation to pay penalty for that, that penalty will not go away even if the law goes away later on. Am I clear? Fifth point talks about affect any investigation, legal proceeding, or remedy in respect of any such right, privilege, obligation, liability, penalty, forfeiture, or punishment as aforesaid, and any such investigation, legal proceeding, or remedy may be instituted, continued, or enforced, and such penalty, forfeiture, or punishment may be imposed as if the repealing act or regulation had not been passed. I will give you a simple example. You must have seen we are talking about decriminalization of legislations, right? So under the company law itself, we have decriminalized, and many other legislations, we have decriminalized provisions, right? So anyone who had done any offense in the prior legislation before decriminalization, that liability will not go away. That investigation will not go away. Say, for example, SFIO proceeded against someone and later on that offense itself goes away. That does not mean that SFIO proceeding will abate or it will go away. It will continue because of the effect of repeal under Section 6 of the General Clauses Act. However, if the law specifically says that previous offenses are also treated as null and void, then that is a different thing. Then, unless the different intention appears, clause will come into picture. I hope I'm giving you clarity on this. Let us have more clarity by way of understanding some situations. Okay, this is one of the situations. Okay, so if you see, I think by mistake I have given you the response also in this particular slide. But okay, anyways, let us read it. Okay. The first situation is the Urban Sealing Act 1990 enables owners to apply for exemption from land ceiling limits. Okay. So Raj is a person who filed an exemption application in 2022 and the competent authority issued an order granting him the exemption. Later on, in 2024, the act was repealed and the new law with stricter restrictions came into existence. So, the state government issued a notice saying that all previously granted exemptions now stand cancelled due to the repeal. Now, Raj challenges this notice, arguing that he had already acquired a vested right under the old act. So, this is the problem. Now, in this problem, if you will see, there are two kinds of situation which can emerge. So here you can see there was a act was repealed with new stricter restrictions. Now, when new law came up with stricter restrictions, if it would have specifically mentioned that any vested rights will not continue, then that would have been a different situation. But here that was not the situation. Here the law got repealed. State government, by way of an interpretation of that law, said that previous granted exemptions are cancelled. Law does not say that previous granted exemptions are cancelled. If law would have said, then that would have been a different story altogether. Here, the state government, by interpreting the law, is saying that exemptions which were granted previously are cancelled. Hence, under Section 6C, repeal does not affect rights, privileges, obligations, liabilities already accrued. And Raj exemption order is right accrued before repeal, and hence, in absence of any different intention in the new act, his right survives. So, cancellation in this case is invalid. Okay, am I clear? I hope you are able to get this. Let us look at the second problem also. So, read this problem. I want your solution to this. You can use the chat box for this solution. First one is under the Prevention of Food Adulteration Act, a criminal complaint was filed against Mira in 2020. In 2023, the act was repealed and the Food Safety Act came into force. The trial court closes the case, stating that since the old act has been repealed, the case cannot proceed. The prosecution challenges this order. What do you think will happen in this case? Yes. You can put your answers here. What do you think will happen in this case? Prosecution is correct, but why? Yes, court is saying cancel old law, but can court say that? in terms of the provision of repeal. Yeah. Yes. Any more responses? Okay. So you see, okay, Kuldeep, thank you for that particular input. So if we say and have a look at this, Section 6E protects investigations, legal proceedings, and remedies relating to liabilities under repealed act. So the case continues as if repealing act had not been passed. Trial court's closure order is wrong. Proceedings must continue because the law does not provide for this exemption. So the previous law came into force, new law in 2023. The violation of the law which existed at that point in time will continue. Okay. So this will not go away. Another example, let us look at it. Under the Entertainment Tax Act, non-payment of entertainment tax attracted a penalty of 100,000, that's 1 lakh rupees. Arun failed to pay tax in January 2021. The act was repealed in 2023 and replaced by a new GST-based system where such penalties no longer exist. The department issues notice imposing old penalty. Arun argues that since the act is repealed, no penalty can be imposed. What is your view? Okay, fine. So in this case, thank you for your inputs. Section 6D clearly states that repeal does not affect penalty, forfeiture or punishment already incurred. Foreign commit the offense before repeal, so liability stands. Penalty can still be imposed as if the repealing act has not been passed. So this is how you interpret the terms of repeal. Am I clear? Yes. Yes, Kuldeep. Thank you. Okay, fine. So this is what is the case. Now let us move ahead and talk about another example. So this is an example of IBC section 243. So generally you will find that the repeal provision which is there in the General Clauses Act is utilized only when there is no repeal provision in the law. Generally, whenever you will have a new law which repeals some provision, it will give sufficient clarity, right? Like, for example, IBC section 243 talks about repeal of certain enactments and savings. You can see here, it says the Presidency Towns Insolvency Act 1909 and the Provincial Insolvency Act 1920 are hereby repealed. For your information, this is yet to be enforced. Okay. But just have a look at it. So it says subclause 2, notwithstanding the repeal under subsection 1, it is talking about 6 clauses, right? So these 6 clauses are talking in terms of repeal. These are specific repeal provisions under IBC, and hence these provisions will always have precedence over the General Clauses Act. This is the basic rule which we have studied in the beginning. And it talks about all proceedings pending under so and so immediately before commencement of this court shall continue to be governed under the aforementioned act and be heard disposed of concerned courts or tribunals as if aforementioned act have not been repealed. So see what it is saying. It is saying any proceeding which was there under Presidency Towns Act and Provincial Insolvency Act will continue under the new provisions. It will not get repealed. So this is how they are providing this provision. I would request you people, you can read this particular provision and similar kind of a repeal provision of some of more legislation to have more clarity and understanding. You can come up with the question on any of the legislation you are reading. And if you have any confusion, please come back to me. I will take your class. This class we will continue in our next, I think Wednesday we are having a schedule. So we will discuss that further in detail. Now, 6A talks about repeal of Act making textual amendment in act or regulation. This is quite an interesting one. And it says, where any central act or regulation made after the commencement of this act repeals any enactment by which the text of any central or regulation was amended by express omission, insertion, or substitution of any matter, then unless a different intention appears, the repeal shall not affect the continuation of any such amendment made by the enactment so repealed and in operation at that time of such repeal. This provision we witnessed, and I'm giving you a lead, and I would request you people to read it on your own. And then maybe in next class, we will deliberate on this more. If you would recollect, in our Companies Act 1956, there was a provision relating to inspector or inspection. Okay. Those provisions, Companies Act 1956 got repealed, and then those provisions got imported by way of SFIO, or SFIO came into existence in 2013 Act. So what happened to that particular provision? There is an interesting question around that. So I would request you people to read this transition, and we will deliberate upon this in a detailed manner in our next class. I would also touch upon this, since we are talking about repeal, Section 7, which talks about revival of repealed enactments. And it says, in any central act or regulation made after the commencement of this act, it shall be necessary for the purpose of reviving either wholly or partially any enactment, wholly or partially repealed, expressly to state that purpose. This section applies also to all central acts made after. So it is saying that in any central act or regulation, if you are trying to revive any repealed law or partially repealed law, then there has to be a express provision, has to be written there. As we saw in case of Presidency Towns and Insolvency Act, express provision like this must be there to revive a repealed enactment. A repealed enactment can be always revived, but there has to be a express provision or express mention of that. Okay. Then Section 8 talks about construction of references to repealed enactments. And if you see, there is this particular section specifically says, where this act or any central act or regulation made after the commencement of this act repeals or reenacts with or without modification any provision of a former enactment, then references in any other enactment or any instrument to the provision so repealed shall, unless a different intention appears, be constituted as references to the so provision so enacted. Okay, I'll give you an example. If you would recollect, in our definition, somewhere we refer to Indian Penal Code. You remember which clause talked about Indian Penal Code? In our definitions, in one of the definitions we discussed was referring to Indian Penal Code. Now you all know Indian Penal Code is now repeated. In place of Indian Penal Code, we have got Bharatiya Nyaya Sanhita. So now wherever you will find the references of Indian Penal Code, it will be automatically substituted by Bharatiya Nyaya Sanhita, equivalent provisions. Say, for example, there is no equivalent provisions, then interpretation has to be found out because the new legislation does not mention the equivalent provisions. So you have to go back to the old provisions as per Section 6A, right? But Section 8 specifically says that you will be referring to the new provisions. Where before the 15th day of this is something which is talking about, there is an example here in Section 115 JB of the Income Tax Act 1961 for calculation of book profits, the Companies Act 1956 are required to be referred. With the advent of Companies Act 2013, the corresponding change has not been made in Section 115 JB of the Income Tax Act. On referring Section 8 of the General Clauses Act, book profits to be calculated under Section 150 will be as per the Companies Act 2013 and not as per the Companies Act 1956. The same example which I gave you in context of Indian Penal Code has been talked about here, right? So this, I believe, concludes our session today. And I am open to questions. One or two questions I will take before we close the session today. Yeah. Any questions or any clarifications till this point? We will continue with this session on Wednesday, and we will complete the General Clauses Act. Yes. Yes, Kuldeep. Tax can be imposed with retrospective effect. Yes, taxation laws have got that, but there has to be a very specific, law to that effect. So if the government says that tax will be imposed from a retrospective effect, it can be imposed. Taxation and procedural laws, they can be retrospective. Yes. Any other question? By operation of law. Okay. So there are situations where you have by operation of law. Operation of law basically means by way of legal, operation. So I can give you an example. Let me think about it. Or anyone else in the room can think about that operation of law quickly. Okay. Like, for example, there is something which is called default of debt. Okay. Like IBC gets triggered after the default of a debt. So any consequence which happens because of that default of debt is by way of operation of law, because law says that if you default in debt, then IBC gets triggered. So any consequence after that on the board of directors or maybe appointment of the interim resolution professional, these are all by way of operation of. I hope you got the example of operation of law. Any consequences or any factual situation which follows by way of application of law is called operation of law. I hope this is clear. Yes, any more questions? You can ask me the questions wherever you have any doubt. So quickly to recap, we have gone through these particular sections. Let me unshare and then I will take you through the slide. Give me a second. Okay. So you are able to see the slide. We have covered till 7 or 8. Now we will be talking about the remaining sections tomorrow, day after tomorrow, and we'll talk about them in detail. Some more examples we will have. If you have any questions, you go through your document, the reading material. And if you have any questions with reference to reading material or any other question which comes to your mind from previous question papers or anything, please do come up with those questions in the class so that we can able to cover everything, whatever is remaining and any ideas which you have. Mr. Linga, if you can further elaborate this question, whether General Clauses Act supersedes any law. General Clauses Act supersedes no law. So if there is a law which provides for a specific provision and General Clauses Act is there and there is a conflict between these two, always the law will prevail over General Clauses Act. General Clauses Act only comes into picture when there is no clarity in the law. Okay, then you move to the General Clauses Act. This I explained in the beginning. Probably you have joined late. Okay. Any other questions? Okay, so if there are no questions, we can, close this session. Thank you for your time, everyone, and have a nice evening, all of you. See you on Wednesday.